inviting me and having me in the Central European Professor Network for the second year running. It's been a great cooperation, and I'm very thankful and grateful for that. So my role is to present the protection of the environment in the Constitution of the Republic of Croatia, which is a rather new constitution, but it has been changed since the 1990s when it was enacted in a way that a lot of people would say that is anti-environmental, but I will come to that later. So, protection of the environment is today one of the most important issues in almost every country in the world. Preservation of the environment ensures protection of future generations as they should be able to live in an environment which offers conditions for a healthy life, which is self-understandable. Such protection is being assured in numerous ways, but it is the most powerful one when the right to a healthy environment is guaranteed by the highest act of the nation, its constitution. But in all prior historical periods, from the ancient period to the Middle Ages and to the modern time, a bit of attention was always placed on the legal regulations of some aspects of protection of the environment: the air, water, seas, forests, nature, and agricultural land. This was also true in Croatian law from the beginnings. Already in the medieval statutes and regulations of cities and communes, we find numerous legal norms regulating the use and protection of water, forests, agricultural land, and so on. In the 19th century, when we were all in the same state, we had numerous very large acts which were designed to protect the environment. For example, the Water Act, the Act on Forests, and so on. The environmental protection is undoubtedly par excellence general interest, which is also self-understandable. Effort to protect and promote the environment is certainly one of the primary tasks of the state, the local self-government and specialized institutions, but also for the society as a whole. Since the protection of the environment is a general interest, it cannot be ascribed to a specific interest like it can be in private law or, for example, civil construction, energetics, transportation, and every other private enterprise. The environment and its protection are supposed to be concerned of every citizen and the entire public. Environment and the care for it are a newer element of materia constitutionalis and is a consequence of a general trend of work of constitution makers on expanding standard constitutional area. Most world constitutions accepted the norms regarding the protection of the environment in the late 1970s. A total of 109 constitutions from 191 existing states mentions environmental protection or natural resources. Among these constitutional documents, the Croatian Constitution also finds its place. In order to achieve the right to a healthy environment, one needs a healthy habitat for humans, which means clean water, air, soil free of toxins, or risks that endanger human health and future generations. This is why the right to a healthy environment is linked with the following obligation of the state: to refrain from any direct or indirect interference with the enjoyment of right to a healthy environment, to prevent third parties, such as corporations, from interfering with the enjoyment of the right to a healthy environment, and 3, to adopt necessary measures to full realization of the right to a healthy environment is achieved. Now, when we look at the constitutional framework of the Republic of Croatia, it does contain several provisions which are important and can be linked with the protection of the environment, but there are problems in interpreting those provisions. But if we look at the constitutional provisions, we will see that they determine, first, the right to a healthy life. This is very important as it is not the same as the right to environment. Second, the obligation of the state to ensure a healthy environment. The commitment of all, within the scope of their powers and activities, to pay special attention to the protection of human health, nature, and human environment. 4, which is very interesting, the provision of special protection to all things and goods of special ecological significance, which are of interest for the Republic of Croatia. We will see that there are 2 types of such goods, and they have different legal settings. And 5, the possibility of restricting entrepreneurial freedoms and property rights for the protection of nature, environment, and human health. The most important article or provision of the Constitution is Article 69, which prescribes that everyone has the right to a healthy life and that the state is obliged to ensure the conditions for a healthy environment. And as I already said, everyone is obliged within the powers and scope of his or her responsibility to pay particular attention to the environmental protection, protection of human health, and so on. This is not the only provision of the Croatian Constitution which is linked with the environmental protection, as Article 3 is extremely important with this regard because it prescribes the highest constitutional values of our constitutional order. According to well-established case law of the Constitutional Court, the provision of constitutional values does not contain human rights and fundamental freedoms, but it is extremely important for judges when they are interpreting any or particular provisions of the Constitution and to guide them when delivering their judgments in specific cases. There is also the Article 52, which is linked with the aforementioned types of goods which are of interest for the Republic of Croatia, and there are some of such goods or things are specifically mentioned in the Constitution, but everything in theory can be by law prescribed as a thing of special interest for the Republic of Croatia and therefore enjoying greater protection. There is also the Article 129a, paragraph 1, which is the only article in our Constitution which is in somewhat directly linked with the care for future generations, as the units of local self-government are obliged to administer in particular affairs related to protection and improvement of the environment. Lastly, as I already said, some constitutional rights can be curtailed if the goal is to protect the environment, and the Article 50, paragraph 2 prescribes that free enterprise and proprietary rights may be exceptionally restricted by law for the purpose of protecting nature and human environment. However, there are numerous problems in practice, as the Croatian Constitution does not explicitly mention the right to a healthy environment. However, one must say that by trying to accept a constitutional document which will be up to date, the constitution maker constitutionalized the preservation of nature and human environment in Article 3, as I already mentioned, as one of the highest constitutional values of Croatian constitutional order. Secondly, Article 69 of the Constitution guarantees that everyone should have the right to a healthy life. However, the same article prescribes it is the duty of the state to ensure conditions for a healthy environment. Moreover, everyone is obliged, as I said, within the scope of their powers and activities, to pay special affection and attention to the protection of human health and the environment. Historically, the right to a healthy environment was introduced into the Croatian Constitution in 1974, when Croatia was still a part of the federal Yugoslavia, and later on in 1990 we enacted the current Constitution, but it was changed in 2010, right in this very important Article 69. If you see the changes, when we look at the original provision from the 1990, it stated that everyone shall have the right to a healthy life, and that the Republic of Croatia shall ensure the right of citizens to a healthy environment. Now, it states that the state shall ensure conditions for a healthy environment. So one could assume that the change from ensuring the right to ensuring the conditions for a healthy environment was a major step back for the constitutional recognition of environmental rights. However, Croatian legal theory predominantly considers that the right to a healthy environment is protected by the Constitution. The right of everyone to a healthy life, provided for in the Article 69, paragraph 1 of the Constitution, cannot, though, be considered as a political or a fundamental freedom. The writers of the Constitution place this right in the corpus of economic, social, and cultural rights, but did not regulate them in detail. However, taking into account the content of Article 69 of the Constitution in its entirety, it can be concluded that the right to healthy life is a special constitutional expression of a broader right, called the right to a healthy environment. One should not mistake the right to healthy life with the right to life, which is enshrined in Article 21 and is linked with the abolition of the death penalty. By stipulating in Article 21 of the Constitution that every human being has the right to life, the writers of the Constitution prescribed one of the basic personal and political freedoms and rights. In contrast, the right of everyone to healthy life, provided for in Article 69, paragraph 1, cannot be considered as a personal or political right or fundamental freedom. It should be noted that the Constitution lists conservation of nature and the human environment among the highest values of the Croatian constitutional order, and these highest values are the foundation for interpreting the Constitution. Therefore, provisions of Article 69 of the Constitution establish certain constitutional obligation addressed to the state, paragraph 1, to acquire conditions for healthy environment, and everyone in paragraph 3. While the provision of Article 69, paragraph 1 of the Constitution relates to the establishment of certain rights addressed to everyone, the right to healthy life. As the constitution maker does not define the term healthy life, and what does it encompass, one could conclude that the right to a healthy life is a special constitutional expression of the broader right which is labeled the right to a healthy environment. The two mentioned provisions of the Constitution are not the only ones which are linked with the protection of the environment. I already mentioned Article 52 and the constitutionally protected goods. Namely, the Constitution stipulates certain goods and things which are under the special protection of the state. Therefore, the state provides special protection to certain things and goods, and as I already mentioned, some are explicitly mentioned and stipulated in the Constitution, and some are not. So there are seashore, islands, waters, airspace, mineral resources, and natural goods, or all natural goods, land, forests, flora, and fauna, or as components of nature, and real estate and goods of particular cultural, economical, or ecological significance. These mentioned goods can be classified into two special groups according to their natural and other features, especially the ability to be the objects of ownership and other real rights. The first group are certain parts of nature, physical things, that cannot be object of ownership and other real property rights, because their natural characteristics do not allow for them to belong to any physical or natural person. These are atmospheric air, sea, and water in its natural course. Such things also include the seashore, which has the characteristic of a common good and recognized by law. These things, common goods, serve everyone, and no one can dispose of them on any grounds in terms of private law. Although they represent things in the natural physical sense, they cannot be the object of real rights because they are not considered as things in terms of proprietary rights. If and when there is power regarding these things, it is not the private power but the public power, and the state is not the owner but only the steward of such things. It is therefore understandable that the Republic of Croatia takes care and provides special protection to such things, because it does not hold ownership but stewardship of these things. All other things, except those belonging to the category of common goods, may be the object of real property rights, which means that they are things listed in Article 52 of the Constitution that do not belong to common goods. These goods and things are specific in the sense that there is a distinction between natural goods, components of nature, and real estate and goods of significance of the state. Among natural goods, seashore, island, and so on are especially highlighted, and in components of nature, land, forests, flora, and fauna are especially highlighted. All these things and goods enjoy special protection of the state, as they can be declared by law as goods of interest of the Republic of Croatia within the limits of the constitutional norm. If they are decided as things of interest of the Republic of Croatia, then the state must provide by law these following things. First, it must specially protect such things and goods. It must prescribe the manner in which they will be used and the limitations of rights on those which can be in ownership status, and compensation for any imposed restrictions. It is very important to say that the Constitution does allow for curtailment of certain constitutional rights if they need to be curtailed because the human health and human environment are to be protected. And that is prescribed by Article 50, Paragraph 2 of the Constitution, which prescribes that free enterprise and proprietary rights may be restricted by law if it is necessary to protect human health and human environment. This is possible although the free entrepreneurship and free ownership is one of the pillars of the economical system of the Republic of Croatia. However, Article 48 prescribes property entails obligations. Holders of a proprietary right and its users shall contribute to the common good. That is why it would be impossible to achieve environmental protection if we would say that ownership is absolute right. So Article 50, Paragraph 2 of the Constitution speaks therefore of the protective function of property and entrepreneurship, which is inherent in the public interest of the community as a whole or a part of it. The Constitution does not guarantee compensations for such restrictions under Article 50, Paragraph 2 of the Constitution. It is also important to note that there are certain constitutional rights without which environmental protection would not be possible. Those are the so-called access rights, and they must be mentioned in this regard. It is obvious that these rights are primarily civil and political rights, especially the right to access to information and right to access to court. However, their use can significantly help in protecting the environment. That is why it is said that access rights are essential to guarantee the protection of the environment and to enable safe, clean, and healthy and sustainable environment. It is important with regard to access to information to mention that Croatia signed and ratified the Aarhus Convention, which came into force in 25 June 2007. In accordance with the Constitution, this convention thus became a part of the constitutional order of the Republic of Croatia, and its legal strength is higher than the domestic law. So it can be applied directly. If we browse to the Constitution, we will see that all aforementioned rights, access rights, are enshrined, of course, in our Constitution. The right to access to information is set in Article 38, Paragraph 4 of the Constitution, and the right to justice or the access to court is enshrined in several articles of the Constitution, Articles 29, 18, and 19. There is, sadly, no direct link to environmental matters regarding the aforementioned constitutional provisions. In other words, the Constitution does not explicitly prescribe that the right to access to information and right to access to court is applicable in environmental matters. The link is thus made through legislature and the practice, very important practice, of the Constitutional Court. The practice of the Constitutional Court also made the link between constitutional right to access to information and the right to a fair trial. This is so although there are few decisions of the Constitutional Court regarding environmental protection, as individual environmental cases arise in front of the Constitutional Court by constitutional complaint, but usually the petitioners do not invoke a violation of Article 69, that Article 38 or Article 29, so access to information, or they claim that the right to access to information or access to court or the right to fair trial has been violated. There are only two cases, one in 2004 and one in 2007, in which the Constitutional Court interpreted the right to a healthy life in an environmental context. In these cases, the Constitutional Court did somewhat elaborate its position regarding the protection of constitutional right to a healthy life and environment. It stated, according to the Constitution, the state is obliged to take every measure to ensure conditions for a healthy life and environment. These measures require, before and all else, bringing adequate acts by which organization, means and conditions according to the protection of the environment is carried out, in the purpose of sustainable development and acts by which unfavorable effects on the environment and health of people would be reduced to a minimum. To conclude, the Constitution does guarantee the right to healthy environment, despite of the fact that it does not explicitly prescribe it. However, there is still no decision of the Constitutional Court of the Republic of Croatia in which such an understanding has been made. Additionally, components of nature and human environments belong to the legal regime of goods of interest to the Republic of Croatia, to which special protection must be given. This implies that, on the one hand, there is a duty of the state to protect them from use and exploitation, which is contrary to the constitutional values and guarantees. So, protection of the environment in the Article 3 is very important in this regard. On the other hand, the state has the right to prescribe the legal consequences of illicit infringement of these goods proportionate to the meaning of the protected good. Thirdly, protection of nature and human environment are also constitutional values that constitute a legitimate reason for restricting property rights and entrepreneurial freedoms, provided that such restrictions are necessary in a democratic society and proportional to the nature and need to implement them in each individual case. Finally, it is very hard, or better to say impossible, to protect the environment without using the access rights, the right to access to information and the right to access to court. Thank you very much.